Thank you very much for the floor, for the screen. As I presume every single member of this research group, I feel honored and pleased to be a part of the group. And to tell the truth, I've been very eager to participate in today's conference because, as I have already mentioned, it was very difficult for me to switch from the substantive approach to interpretation of fundamental rights to methodological approach, especially from the point of view of the Slovak Constitutional Court. Nevertheless, thank you very much for your support, Zoltan, and I'd like to share my result of the research. I knew that I would be in the late afternoon, so I'll try to focus on the most important points as for the Constitutional Court itself. And I'd like to include also some comments to the pre-speakers of mine. I'm especially thankful, David, for your presentation because, as you'll see, it is quite obvious that we have shared common history of the legal culture during our common history of state existence. So I'll point it out during my presentation as well. In general, I have divided my presentation into 4 parts. First of all, of course, I'd like to present the Slovak Constitutional Court, its position, competence, and proceedings, not in details. Then I found it very important to explain what is the position of the European Convention of Human Rights within the, within the Slovak legal order. Then I have found the selection criteria very decisive for the result of the research. And by presenting the results of the research, I'd like to answer the question whether there is a prevailing approach in the reasoning. I'll present my, let's call it, expectations, whether they have been approved or not, and whether I have come across any surprises. So, distinguished colleagues, ladies and gentlemen, let's go for the reasoning within Slovak Constitutional Court. When I listened to Slovenian and Polish presentation, I had to, in a way, smile because I guess that, formally speaking, the Slovak Constitutional Court is one of the youngest judicial bodies on the constitutional level. It started its functioning on 1st January 1993. It is a separate judicial body and it's aimed to protect constitutionality. There are 2 important legal acts for its functioning, of course, the Constitution itself. And later on, I'll talk also about the special amendment that has changed the position or the competencies of the Constitutional Court, also in relation to Strasbourg, and then the act on the Constitutional Court itself. The seat of the court is in Košice, the second biggest city in Slovakia. It is supposed to have 13 judges. They serve for 12-year term. Quite opposite in comparison to Slovenia. In Slovakia, the National Council proposes the double number of candidates, and then it is upon the President of the Slovak Republic to appoint the judge. Because of some political reasons, there were, let's say, days, but even longer than days, when the Constitutional Court was not actually functioning because of political tensions between the President and the National Council. Since the National Council, of course, this is the supreme legislative body, but as we know, it is a political body as well. So the whole process has been politicized, highly politicized, and there was a problem to actually have the Constitutional Court functioning. and it has, in a way, it has been reflected also in the, sadly, sad, but also in the decisions of the Constitutional Court. As for the competencies, as usually, also the Slovak Constitutional Court decides upon the conformity of legal acts and international agreements with the Constitution. Since I've included also one decision about the subject and result of the referendum, I've included here into the presentation as well that it decides upon the conformity of the subject and result of the referendum. Because of the current situation, I'd like to point out also the competence upon conformity of the declaration of the state of emergency. It has been used actually for the first time now during the pandemic situation. And it decides upon the vacancy and indictment of the president as well, and as generally when speaking about constitutional courts, as far as I know, of course it has to decide also upon the competent disputes. And in relation to the topic of our research, it decides also upon complaints from individuals and local self-government bodies. It is very important to point out that before the great amendment of the Constitution in 2001, even the Strasbourg Court decided that the constitutional complaint of individuals was not a means of necessary to exhaust domestic remedies. So you didn't have to submit your complaint at the Constitutional Court to get to Strasbourg to exhaust domestic remedies. Strasbourg decided that that was not an effective means of protection of fundamental rights. Nevertheless, that was changed, and nowadays it is considered to be an effective means. On the other hand, there are other procedural aspects that bar effective realization of effective protection of fundamental rights. That has been actually proved now during the pandemic situation. As for the proceedings, just in shortly, the motion might be submitted by at least 1/5 of all members of parliament, also by the President of the Slovak Republic, that has already been used several times, by the government, by any general court, the Attorney General, Ombudsman, of course, by acts of individuals. The complaints or the motions are decided by a Senate that are composed of 3 members. One of the members is the judge rapporteur that prepares the decision. It might happen that different Senate, of course, adopts a different conclusion, because as we know, as it has already been said by you, Professor Karakamiševa-Jevanovska, thank you very much. The rights are the same, but the interpretation might be different. So if such a situation occurs, then one judge rapporteur has to submit a proposal how to come to a conclusion that could unify different legal opinions, because the Constitutional Court, of course, would like to avoid legal uncertainty that is created by different legal opinions of different senates. In my chapter, I also try to compare the different aspects of the proceedings just shortly in comparison to 6 months of the period that cannot be exceeded if you'd like to submit your complaint to Strasbourg. You've got only 2 months by the entry into force of the act that you would like to complain against, so it's quite shorter. What is now a point is that if there are other courts that might decide upon your complaint, then the Constitutional Court says that it won't take your complaint into consideration, and the interpretation of a special part of the Constitution or special norm is quite exhaustive, and especially now during the pandemic situation, the Constitutional Court didn't actually want to decide upon the complaints in this area. Unlike the European Court of Human Rights, the Constitutional Court of the Slovak Republic has got the authority to suspend the enforceability of the examined acts. And unlike in relation to the Strasbourg Court, the Košice Court, you cannot submit an appeal. Nevertheless, again, there has been a change as well. And if there is, of course, a decision of international judicial body, then there must be a possibility to reopen proceedings at the national level. Nevertheless, it has been very interesting while reading the decisions that not all the decisions have already included this note for the party. Technically speaking, it has been also interesting to find out that as for Strasbourg decisions, the Strasbourg presents the facts and then the reasoning that leads to a conclusion. The Slovak Constitutional Court presents, states the conclusion and then explains why it has come to such a conclusion. Now, moving to the other part, to the second part of the presentation, to keep the time limit. European Court of Human Rights within the Slovak legal order has special position because according to our constitution, some international treaties have precedence over laws, nevertheless not over the constitution itself. And the great amendment that I already mentioned is the milestone, because before 2001, the situation was different. Nowadays, there's a list of areas that might be covered by international treaties for whose exercise the law is not necessary and which directly confer rights or impose duties on natural legal persons, and they are ratified and promulgated in the way laid down by law. Nevertheless, before 2001, it was enough for them to be ratified and promulgated in the manner laid down by the law. And the only condition otherwise was that they had to provide a greater scope of constitutional rights and freedoms. Since the convention was, Slovakia became a party to the convention before 2001, the status of the convention hasn't changed. So it means it is still, not only it has precedence over laws, but it is a part of our legal order. And unlike, for example, if compared to Poland, if you read the oath of judges, they are not only bound by the constitution, constitutional laws and laws, but also international treaties that fulfill these conditions, that meet these criteria, and they have to admit that they have to apply the convention that has precedence over law. Nevertheless, I found it very limiting, and now I'm moving to the part about selection criteria, that there are many important cases of the Slovak Constitutional Court within the last 10 years that was the common criteria, objective one, for choosing, for selecting decision of the Constitutional Court, that many of those cases, they miss case law of the European Court of Human Rights. Of course, subjectively speaking, we have to choose 30 decisions. My research focuses much more on the Strasbourg judiciary, so I have asked also my colleagues what they found important in relation to the case law of the Slovak Constitutional Court. Also, I have researched the annuaries published by the Constitutional Court, but it was very limiting to find out that, as I've already said, not all really important decisions include reference to case law of the European Court of Human Rights. And when I try to find out the reason, because it's, formally speaking, if the convention has precedents, it should be referred to, and the case law of the Strasbourg is very decisive. I was told that it might be because of the age of the constitution itself, and also because of the age of the judges, because previously there was not, they were not used to referring to international treaties. I have found it very annoying after so long time that somebody could propose it as an explanation, but nevertheless it is true that it was very limiting factor, criterion to choose decisions that could be a subject of the research. And another limiting factor, decisive factor, was that really the political tensions, even within the composition of the Constitutional Court, was, according to some colleagues, very, very decisive. Nowadays, for last year, we even call it a new Constitutional Court, and we'll see whether the experience of not referring to the case law of the European Court of Human Rights will change or not. Let me move to the following part of my presentation. I have chosen two quotes of our Constitutional Court to present how the Constitutional Court of the Slovak Republic itself sees the interpretation. It has clearly pointed out that interpretation cannot be realized only in relation to the text of a norm. And what I found very interesting, not even in a case when the text appears to be unambiguous and definite, but first of all, according to the meaning and purpose of the norm, as well as in the interest of constitutional principles, including protection of fundamental human rights. And what has been even more striking, the Constitutional Court held that general courts are not absolutely bound by the literal wording of the law, but they can and must deviate from it if required by the purpose of the law. So within the first part of my chapter, I have presented what the court itself has said about the interpretation, and then I did a research upon those 30 decisions. And as you'll see, the statistics differ from what the court has presented itself. Nevertheless, again, I think that it might be caused by the set of decisions that have been selected. I still hope, yes, I still have time. So to mention the most statistically speaking, as for the quantitative results, almost all of the methods of interpretation that have been agreed upon have been used by the court. As for the textual interpretation, there were even two cases that the court referred to dictionaries. What was much more important, that was the legal definition, that even if it started with ordinary meaning, it then moved to legal interpretation that might be different from the ordinary meaning used within the words. Also, the logical interpretation has been detected, not quite often though. And to move to the most used argumentation, it has been found out that the systemic argumentation has been used most, especially in relation to the domestic systemic argumentation. As for the contextual argumentation, it has been used almost in half of the cases, and the most used approach has been the reference to own case law. It might be compared to the Czech Constitutional Court as well. In 25 decisions out from those 30, actually the court has said that it has already decided in this way, and it won't change its position. And nevertheless, there was one case when the court has pointed out its previous decisions by saying that it has already changed its reasoning and decisions. So that was that the one party wanted to point out previous case law, and the court said yes, but we have already changed the reasoning and position. It has referred to ordinary court decisions as well in 5 cases. I have included Supreme Court into the system of ordinary courts because in Slovakia, Constitutional Court, it is a separate, it is not a part of the ordinary court system, but the Supreme Court is. So when I referred to ordinary court decisions, I've taken into account also decisions of the Supreme Court. And it has happened that the Constitutional Court actually repeated the reasoning of the Supreme Court and said that the reasoning was all right, and that's it. And it has also referred to other domestic bodies. It is not only the fact that the other domestic bodies have been a party to the proceedings, but their reasoning has been it's repeated by the Constitutional Court in its reasoning. And that's why I've included 11 cases out of 30 into the statistics that yes, even other domestic bodies have been referred to, not only as a party to the proceedings. As for the external systemic argumentation, of course, as we know, the European Convention on Human Rights and Fundamental Freedoms hasn't been taken into account in this part because it is criteria for the decisions to be selected. Nevertheless, there are other treaties that have been included. It happened in 14 cases. And it was an example of covenants, both covenants, and also the Convention on the Rights of the Child, other different bioethics decisions, bioethic agreements. Most of those international treaties were adopted on the under the umbrella of the Council of Europe. Slovak Constitutional Court loves referring to international bodies as well. I've detected in 9 cases out of 30. It was very interesting for me to find out that it refers even to International Law Commission and the draft articles on responsibility as the authority to be referred to. And not surprisingly, even foreign legal systems have been referred to quite often. I'll say that in the conclusions that our brothers from the Czech Republic are an example to be followed according to our constitutional code. So the Czech Constitutional Court Judiciary and the German Constitutional Court Judiciary is often referred to. Other means of argumentation have not been used so often, except for scholar works. I'm an academic, but it was sometimes even astonishing for me to find out how often the argumentation based upon scholar works has been used. I'm not saying that it was decisive though. On the other hand, I was surprised that sometimes even pages referring to scholar works, and as it was presented also by David, especially of course to Slovak, not only, but especially to Slovak legal, Slovak scholar works have been referred to. it has been presented mostly to some very important scholars, but also some not known scholars if they were decisive in the argumentation line that was necessary to be stressed that it was used. I hope I still have some time, but to go through, as I've already said at the beginning, it was interesting for me to move from the substantive approach to the methodological approach. I haven't included into the chapter, so I thought that at least for the presentation I could say some words about it, but I see that I'm moving out of time, so that's why just statistics also about the material substance of the decisions that I found interesting when I choose the most important decisions of the Slovak Constitutional Court. Actually, what would be the survey sample then in relation to material substance? And I've come to the same conclusion as for the methodological approach of the European Court of Human Rights, that it was very important for the court that the interpretation has to lead to conclusion that the protection cannot be illusory but effective, and the fact that the court has used all the methods indicated in the Vienna Convention on the Law of Treaties, nevertheless not so much on the good faith, but ordinary meaning, so it means text, context, and object and purpose of the convention. I think that the Slovak Constitutional Court is in a way moving the same way as for the referring to its previous case law, because I've included the comments into the chapter that at the beginning, of course, if we mentioned, for example, Golda case, there was not much case law, so it was not that much, but nowadays the decisions, they have to choose which are the most important decisions. But nevertheless, there's the snowball effect, as David has already mentioned. Coming to the conclusion, not only statistically speaking, I think that despite the position presented in the decisions, if formally speaking about the interpretation, the text is not only a starting point, it is always very important as the own case law. Another very important and supportive argument is external systemic argumentation. It was not only, I've mentioned German Constitutional Court and of course the decisions of the European Court of Human Rights, but I've detected also the decisions of the Inter-American Court of Human Rights. And as I've already mentioned, it was very surprising for me to find out how often the court mentions the scholar works. It was presented that judicial authority is supported by academic authority, but I think that the composition of the court might be the reason why the scholar works are referred to so often. And finally, the conclusion dealing with the material core of the Constitution. This is something very discussed these days in the Slovak Republic, because there was a decision, there was a legislation adopted by our National Council that the Constitutional Court cannot decide upon conformity of constitutional acts with the Constitution. So actually now the judges, as they look for the way, all right, so we cannot decide upon conformity of constitutional act with the Constitution. What about the material core of the Constitution? It is not written, but maybe the values that are important for the Constitution and democratic society might be the way for us to decide and to preserve the division of powers within the Slovak Republic, that is a parliamentary republic. On the other hand, there are calls for paying attention to the fact that if the material code is not included into the convention itself, not even with some, at least some written aspects, then it might open the path for judicial activism. And then at the end of the day, the Constitutional Court that is consisted of 13 individuals might later create a bigger problem for interpretation of the substantive one of human rights, fundamental rights within our state. I would like to thank you for your attention, for your presentations, because the research itself, the presentations I've heard, they have given me more questions, and I think it is very important to react to questions and to learn from each other, as today has already been mentioned at the beginning of the conference. So I look forward to the discussion and further cooperation.